Mr. Fahey?
Thank you.
I got 1 second before Will. You had asked for the general order that was referenced.
Yes.
G03-02-02, and it's exhibit, defense exhibit 56.
Thank you.
Thank you, Judge.
And Your Honor, if I could also adopt, I can't remember if I did, my argument in motion for directive finding.
I think you did.
Oh, I think I did. I actually forget if I did or not. But Judge, I would like to start, I think it's important, Judge, that we not lose sight of Tom Gaffney's role in all of this. He and his partner, Joe McElligott, were the two police officers that responded to Rudy Barillas' emergency call for help to 911. They are the two police officers, and it was described by the state's witness, Sergeant Snelling, who acted with great professionalism, exercised real patience and restraint in trying to quell a very dangerous situation. And I don't think we need to lose sight of that, Judge. And after this incident happened that involved Officer Gaffney, because we know in the end, Laquan McDonald did defeat his arrest and did make his good his escape on Pulaski Avenue. We should also consider, Judge, my client's actions afterwards. He was interviewed at the scene. He described in great detail for a detective, Detective March, exactly what he did from the time he responded to the call to the time he arrived at 41st and Kildare to the time that he drove north to 40th Street and encountered Laquan McDonald for the first time, how his partner got out of the spot, how they very patiently followed, ordering him to just drop the knife. And Sergeant Snelling was very complimentary of how my client trailed and his squad, called for additional police resources, and called for a taser. He did what any great police officer would do, according to Sergeant Snelling. He described all of his actions, everything he did, everything he saw, the entire time of his involvement. And he did that at the scene, Judge. And there has never been even a whiff or a suggestion of any kind that Tom Gaffney was anything less than honest and forthcoming about everything he did in his actions in this case. Somehow that seems to have gotten lost. And his interviews didn't end with the detective. He fully cooperated with the independent criminal investigation that he now stands charged with obstructing. You have that testimony, Judge, all 47 pages of it. Never, ever, in all of those interviews, was there ever a hint that Tom was anything less than honest and forthcoming in describing what he did.
Objection, Judge. We don't even have half of those interviews. They're guaranteed protected. That's an improper order.
Okay, that's sustained. I'm only going to consider the exhibits that were admitted in the testimony that I heard at trial.
Okay, to clarify, Judge, the interviews that Your Honor has.
Okay, thank you.
So, it begs the question, Judge, if he didn't see the shooting, and he's completely honest and forthcoming about his involvement in what he did in regards to this case, how in the world does he ever become a co-conspirator to obstruct the justice or obstruct the true facts of what really happened with regards to the shooting of Laquan McDonald? It just doesn't make sense. So to understand the state's theory with regards to Tom Gaffney, and Judge, I'm not suggesting I do understand it, but I think it goes something like this. I think it goes something like, thank you, Tom. Thank you for your professionalism. Thank you for everything you did out on that street. We need great officers like you who can take those actions and be patient like that to try to de-escalate very dangerous situations. And you know what, Tom? Thank you. Thank you for your honesty during the investigation of Detective March in describing what you did. We need honest police officers out there. But if I'm to understand this, what they're really saying is, after this exhaustive investigation of theirs, they think they found a mistake in one of Tom's reports. It was filled out hours after the incident, hours after he had already been interviewed about the entire true narrative that he gave to the detectives. And so he finds himself before you, charged with a crime for possibly, and I'm saying possibly, Judge, a mistake on his officer battery report. How about that for some gratitude for his excellent police work and his honesty? Judge, a mistake is not a crime. And disagreeing with a police report doesn't make the report writer a criminal. The TRR, I don't know what the state would have him do. Their own expert said he filled it out the right way. Absolutely, 100%. Every day of the week, the actions of Laquan McDonald, those actions are those of an armed assailant. And yes, in that hypothetical, which is the fact scenario before you, he absolutely should have checked every one of those assailant boxes. That's why he was indicted. I believe that's paragraph 21 of the indictment, for checking those assailant boxes. Now, after the state presents their witness, they're saying, well, you know what? Now we think he should have checked the fleeing box. Sergeant Stelling said that you describe the actions of the subject at that location, 40th and Coverup. At 40th and Coverup, Judge, Laquan McDonald wasn't fleeing at that point. He was attacking. That's why he was an armed assailant. And that's why the state has to concede that he filled that out properly. And that brings us to the other report that Tom generated this. It's called an officer battery report. And Judge, I think if this trial has established one thing, there's an awful lot of limitations to that report. That report couldn't be any further from being a perfect report. Starting with the name, officer battery report, that we now all know includes officers who were assaulted. And I don't know how the state would have Tom fill that out. He clearly indicates on the report, and it's Gaffney OBR 1, that he wasn't injured. He's not saying he was ever battered. No one has ever saying that. He gets criticized for saying he checked the box. I shouldn't say criticized. He got indicted for this. Under manner of attack, he checked the box that says stab/cut, parentheses, including actual attempt. He was indicted for that. Their own witness described Laquan McDonald stabbing with the knife. He stabbed the front tire. And then he turned and he faced my client as my client inched up, desperately trying to keep him away from a populated area. And Laquan McDonald raised that knife, looked right at him with a raised knife, and he swung that knife down. And it hit the windshield. Joe McElligott described it as slamming off the windshield. So when counsel asked, why would he check the box that says other and list swinging the knife? Well, how about this, Judge? He did it because that's what Laquan McDonald did. He swung the knife. Their evidence shows that. And he checked the box that says knife because there's no mystery here that he had a knife. And then it gets down to what has now become, Judge, not a mistake, but a disagreement. The box that says number of officers battered, also number of officers assaulted. And he places the number 3 in there. Why did he do that? Well, Judge, the reason why he did that is because the police department was treating it as one incident. So they're all under the same RD number.
No, it,
Oh,
no.
I understand. This is just argument. It's not evidence. I will consider the evidence, and the argument should be based on the evidence and reasonable inferences to be made from the evidence.
Judge, at the very top of that report is the RD number. It's the very same RD number a Detective March has reviewed. And Sergeant Snelling didn't say that by placing number 3, he committed a crime. What Sergeant Snelling said was by listing the number as 3, I would have corrected that if I was the sergeant out at the scene. If I was at the area, think about this, Judge. The Sergeant Snelling, according to the state's evidence, if Sergeant Snelling was out at the area reviewing Tom's report, Tom wouldn't be sitting here. Because then there would be no mistakes in his reports. But they're suggesting that by him placing 3 on that report, he made a mistake. And there's a disagreement between Sergeant Snelling and Tom Sergeant Franco, who signed off on that report. Remember the responsibility that Tom's supervisors had with these reports. Sergeant Snelling told you it's actually in the general orders. They are responsible for the completeness and the accuracy of those TRRs and those OBRs. The sergeant has that responsibility, the lieutenant has that responsibility, and the deputy chief has that responsibility. And they disagree. They thought that was correct. Sergeant Snelling doesn't agree with that. And that is why Tom is seated over there. And that's tragic, Judge. So what you have here, Judge, is at best an imperfect answer to an imperfect question on a form that is far less than perfect. And from that, the state over here wants to infer some type of conspiracy that somehow this report moved the ball for Jason Van Dyke. It's a completely separate incident that he's describing. It's 40th and Carlo. And there is nothing that Tom Gaffney did in that report writing or the detailed narrative that he gave to Detective March at the scene. None of it helps Jason Van Dyke. So how could he possibly be a co-conspirator? Not to mention that there's no evidence of a conspiracy. So now when the state stands up in front of you, Judge, they now suggest, Tom, you shouldn't have done any reports. You're not a victim of an aggravated assault. On what planet would that fact scenario not equate to an aggravated assault? You have an armed assailant refusing to put down the knife. You have Officer McGilligan testifying that every step he took closer to Pulaski, he got more and more dangerous. When my client tries to make a tactical maneuver to keep him from that populated area, What does Laquan McDonald do? He takes that knife and gashes the tire with enough force to gash the tire and pop it, flattening the tire. Tom's not giving up. He's still trying to divert him. He inches up, and Laquan McDonald is right outside his squad. And what does he do? He turns towards him, raises the knife at him. Now, what reasonable person would not think when you have an armed assailant who's been doing what he did the entire way down 40th Street, now turns and raises that knife at you? Under what reasonable objective standard would that not be considered an assault made aggravated by the knife? It's disingenuous for the state to stand up here and even suggest something like that when their own evidence from Officer McElligott and Sergeant Snelling clearly state he was absolutely an armed assailant. He absolutely committed an aggravated assault. And to try to suggest when Tom is questioned in the grand jury, when he's given testimony, when he's still cooperating, when he's asked a question by one of the three prosecutors who questioned him, okay, you never personally felt at risk of death or serious bodily harm from this offender? Is that fair to say? Answer, pretty much, because I was still in the car. And he goes on to explain. Well, Sergeant Snelling also testified about that, Judge. The fact that you're in the car doesn't change the classification of the armed assailant. He called it shielding. What Sergeant Snelling told this court is that explains exactly what Tom was trying to explain in the grand jury. It explains why he didn't shoot him. But it doesn't change the fact that he was a victim of an ag assault, and it doesn't change the evidence that the state presented that it was an ag assault and that he was an armed assailant. Judge, you have the entire grand jury transcript, and most of it was published to you. The entire transcript is in evidence, though, Judge. In this notion of some type of an agreement, I don't know what the state is trying to suggest. They joined in on some of the agreement to conspire to obstruct justice by concealing the true facts of what happened when Laquan McDonald was shot, even though he didn't say it. Or I'm sorry, even though he didn't see it, I misspoke. He does talk in the grand jury about going back to the area hours later, and there was a meeting there. Yeah, all the police officers were there in the detective area, the large open detective area. And they were talking to the union representatives. There's nothing wrong with that. They had already been interviewed. They're entitled to union representation after the detectives are conducting their interviews. And there's nothing wrong with some other detectives, no one's saying it's Detective March coming up and talking to one of those officers. That's not a conspiracy. That's standard operating procedure. It happens in every police-involved shooting. But what the state misses, and what's most important about those 47 pages of my client's grand jury testimony is, my client is now on trial for obstructing that investigation. And they're suggesting to this court that he obstructed that investigation by preparing those two form reports. Nowhere in that transcript, my client gave testimony to 3 different independent criminal investigators, 3 different prosecutors. Never, ever, ever is he asked about those forms, because they were completely unimportant to the investigation. I believe Mr. Breen used the term immaterial. If there's a truth detector that shows you that they were immaterial, it's that grand jury testimony, Judge. Judge, police officers are not perfect. I concur with Mr. Breen. I know I'm going third, so there's not a whole lot left for me to say. They are not robots. We don't have robots patrolling their streets. We don't have robots filling out police reports. Their job is completely different from what all of us do. But the one thing they have in common, Judge, with us is they are human. They're human beings. And it's easy for us. It's easy for us, Judge. We get up in the morning, we shower, we put on these nice clothes, we go down to our offices, or we come to a secure courthouse like this. The most dangerous thing I did today, Judge, was crossing California from the parking lot to get into the courthouse. Police officers, they aren't different. When they start work, Judge, they start by putting a bulletproof vest over their chest. They strap the semi-automatic weapon to their hip. They answer calls from people like Lisa Willis and go to very dangerous situations. Sometimes even they have to kick in doors and know what's waiting on the other side. So, Judge, the other thing that I don't think we need to lose sight of is sometimes a police officer has to make a split-second decision to shoot or not shoot, to fire or to hold fire. Tom had to make that decision, along with Officer Walsh. They chose the latter. And you know what? The state has their way, it doesn't matter. Because in this case, you're damned if you do, and you're damned if you don't. And I don't know how to say this, Judge, any other way, but there's something about that that really, really stinks. These men did nothing wrong here. These men committed no crimes. And I'm asking you, Judge, to start undoing some of the falsehoods that have been said about these men, about Tom Gaffney. I'm asking you to do that, Judge, with your finding, and to find him not guilty of the crimes that he has been wrongly charged with. Thank you, Judge.
Thank you.